How are everybody?
We are doing well. Our participants are eager to hear what you have to say about the strengthening of the climate governance and your experience in Australia.
Great, thank you. Are you ready for me to begin?
Yes, we are. Thank you.
Great. Thanks very much. So thank you so much for inviting the Australian National Anti-Corruption Commission to participate in your conference to mark International Anti-Corruption Day 2024. My name's Kylie Kilgour and I'm one of the Deputy Commissioners at the Australian National Anti-Corruption Commission. As is now custom in Australia, I will start by acknowledging the traditional custodians of the land known since colonisation as Melbourne, from which I'm presenting today, the Wurundjeri people of the Kulin Nation, and their continuing culture and connection to country. I pay my respects to their elders, past and present, and also to any First Nations people who are participating in today's forum. I'll begin by noting corruption is a transnational problem, and the prosperity, peace, security, and stability of our region depends in no little part on enhancing our collective commitment and capability to combat it. Our respective anti-corruption commissions first met a year ago in Atlanta in the margins of the 10th Conference of State Parties to the UN Convention Against Corruption. More recently, on the 16th of September 2024, my Commissioner Paul Brereton hosted a delegation of 6 senior officials from your key independent government accountability agencies, including the President of your Anti-Corruption Commission, in our head office in Canberra, as part of the Australian Department of Foreign Affairs and Trade's Canberra Fellowship Program. We hope this marked the beginning of an ongoing collaboration between us. As many of you will be aware, climate finance emerged as the key focus last month at the 29th Conference of the Parties to the UN Convention on Climate Change. With new data predicting 2024 to be the hottest year on record and the increase in costly extreme weather events, COP29 aimed to solidify global cooperation in the field of climate finance. The scale of investment required is immense, estimated by some experts to require trillions of dollars. Ensuring that climate finance is utilised only in the public interest to deliver the projects for which it has been made available is a significant challenge for all anti-corruption agencies, as well as governments, civil society and citizens. Before I address the specific topic I've been asked to talk about this morning, I am conscious we are a very new agency, having only commenced operating in July 2023, and some of you may not have heard about us. So I will provide you with a brief outline of the role of the Australian National Anti-Corruption Commission, which is also sometimes referred to as the NAC. You may find what I'm about to say useful to compare with your own Anti-Corruption Commission's jurisdiction, legislation and operations, and I'm happy to answer any questions you have about us at the end of my remarks. So I'll begin with an overview of the Commission's functions and jurisdiction, including how corrupt conduct and a Commonwealth public official is defined in our Act. I will outline the strategic corruption priorities we are currently focusing on, many of which are relevant to the issue of climate finance. I'll then make some comments about what we see are some of the origins, root causes or enablers of corrupt conduct and how these apply in the field of climate finance. Finally, I'll outline what anti-corruption commissions can do and what current research suggests we can collectively do to protect against corruption of climate finance. As many of you may be aware, we are the last of the anti-corruption commissions to be established in Australia. All of our states and territories have had local anti-corruption commissions for many years, starting with New South Wales in the late 1980s. After many years of calls for a national anti-corruption agency, a federal government commitment was secured in mid-2022 and legislation to establish the commission quickly passed through our federal parliament in late 2022. Our first day of official operations was the 3rd of July 2023. We have an operating budget of around 60 million Australian dollars per year, and when recruitment of all our staff is complete later this year, we will have around 260 people working in the Commission. We were established to provide independent assurance to the people of Australia that corrupt conduct involving Commonwealth public officials is prevented, detected, investigated and responded to appropriately. We have adopted as our mission to enhance integrity in the Commonwealth public sector by deterring, detecting and preventing corrupt conduct involving Commonwealth public officials through education, monitoring, investigation, reporting and referral. To achieve that mission, we have two main lines of operation: deterring corrupt conduct through detection, investigation and exposure, and preventing corrupt conduct through education and engagement. In general terms, when we talk about corruption, we mean the misuse of public power, position, privilege or property for private purposes. Under our Act, a Commonwealth public official engages in corrupt conduct if they breach the public trust, abuse their public office, or misuse official information. In addition, any person engages in corrupt conduct if they do something to cause a public official to behave other than honestly and impartially in performing their public duties. In this way, it captures conduct by any person that could adversely affect a public official's honest or impartial exercise of powers or performance of duties, such as offering a bribe or inducement. The definition of corrupt conduct extends to attempting, conspiring, or planning to engage in any of those types of conduct and participating in another's corrupt conduct. Our jurisdiction is concerned with corrupt conduct that involves Commonwealth public officials, either by them or affecting their honesty and impartiality. A public official is defined to include Commonwealth parliamentarians, including ministers of state, and staff members of Commonwealth agencies. The definition of a staff member of a Commonwealth agency includes not only individuals employed by the agency, but also those who are engaged in any way to assist the agency, and this clearly captures those retained as consultants and advisors, including, for example, consultants engaged to provide expert climate policy advice to government. It also extends to individuals involved in delivering services to or on behalf of the agency under a contract with the Commonwealth. For example, the recipients of government contracts and in some cases grants to fund climate change response and mitigation initiatives. Considering the extent to which governments in Australia have in recent years retained external consultants and the extent to which the delivery of many Commonwealth services has been outsourced to contracted service providers, this is a large field which is already attracting the Commission's attention, and we consider it will continue to do so. As is the case with all anti-corruption agencies, we are resource constrained and we have to make difficult choices about where we put our efforts. To assist us with this, the Commission currently has 6 strategic corruption priorities. These are the thematic areas that we want to focus on to have the greatest impact on corruption in the Commonwealth public sector. These priorities are not inflexible. The Commission continues to pursue matters that fall outside the priority areas where there's reason to do so, but a matter that falls within a priority is more likely to gain our interest, all else being equal. Corruption issues arising in climate finance align with 5 of these 6 strategic priorities. So these are complex procurements, senior public official decision-making, contractors and consultants, the environmental sector, and corruption affecting vulnerable people. So turning now to the topic for this morning's session, as a general comment, in preparing for today's remarks, I've come to the view that I don't think climate finance is necessarily more vulnerable to corruption. In my line of work, I see common corruption risks wherever there are large sums of public funding being dispersed. But there are some specific corruption vulnerabilities applicable to it. Also, the consequences of climate finance corruption are particularly critical in the context of the current challenges to improving our climate and the environment more broadly. But I acknowledge I'm a corruption expert, not a climate expert, and so I'd be very interested in hearing other people's views about what I've got to say about this. As described in, I'm just going to point to this document, in this recent discussion paper released by the UN Office on Drugs and Crime and the World Bank titled Addressing Corruption Risks to Safeguard the Response to Climate Change, the term climate finance is used to describe a specialised form of funding designed to tackle the challenges of climate change. It encompasses local, national and transnational financing, drawn from both public and private sources. Climate funds refer to the specific financial instruments, including stocks, bonds and loans, grants and other pools of money set up to channel climate finance towards particular goals or projects. The paper notes that at present, most climate financing in developing countries stems from public sources. It suggests that to close the financing gap and accelerate climate mitigation and adaptation activities, private financing needs to be encouraged. However, their research also suggests the perception of corruption risks is undermining private sector confidence in joining climate finance operations. Corruption is thus a barrier both to raising much needed funds as well as to their effective use to adapt to and mitigate the effects of climate change. Carbon markets are also a significant component of climate finance. They are a carbon pricing mechanism enabling governments and non-state actors to trade greenhouse gas emission credits. Both the compliance and voluntary markets are known to be susceptible to corruption. In Australia, we recently had an independent review of the Australian carbon credit scheme, which has made some recommendations to enhance the integrity of that scheme. And that report is available on our Department of Climate Change, Energy and Environment Waters website for those who are particularly interested in that topic. It's important to acknowledge that research on corruption risks and how to prevent these risks from materialising relating to climate finance is still emerging. But for the purpose of today, I'm going to speak briefly about what I'll describe as the current top 4 corruption risks before turning to what can be done to address them. Firstly, from the work of many of the anti-corruption commissions around the world, including, I'm sure, yours, we see that almost invariably corrupt conduct will have its origin in a conflict of interest. That is, where a public official's personal interests are preferenced over the public interest or their public duties. In the case of climate finance, such conflicts of interest can result in regulatory distortion to favour personal and political interests, bribery of public officials, fund misappropriation by public officials, and favoritism in awarding contracts to friends and associates of public officials. Secondly, there is a great deal of complexity in climate finance arrangements. This includes a complex network of institutions, financial transactions, procurements, and delivery agencies, including by those in sectors with well-known high risks of corruption, such as construction, forestry, and energy. What is being financed is often highly technical and innovative. The financial arrangements and who stands to benefit from them can be opaque to many of us and provide opportunities for overpricing, market distortions, and misallocation of funds. In the case of carbon offsets, the abstract nature of the carbon market and lack of regulation can make it fertile ground for bribery, deceitful claims of compliance, and greenwashing. Thirdly, significant sums are being invested globally. The discussion paper by the UNODC and the World Bank estimates between 5 to 7 trillion US dollars in annual investments will be required to green the global economy by 2030. They also note this will create opportunities for embezzlement if oversight mechanisms are not in place. And finally, the urgency of the challenges associated with the climate means there can at times be a rush to spend. Governments may relax financial and governance controls to facilitate this. projects may be rolled out without sufficient controls over known corruption vulnerabilities. This can lead to poor policy and program development, a lack of due diligence regarding who is being procured to deliver, and a lack of monitoring, reporting and evaluation of climate finance projects, all of which can make climate finance susceptible to what I'll describe as corruptors, such as organised crime groups, who will find ways to manipulate arrangements to benefit themselves. So, with that in mind, what can we do to prevent these risks from ruining the good work climate finance is aiming to achieve? First off, I'll mention some of the strategies the Commission has adopted or is available under our legislation that may be of interest to you, and it may be applicable in your context. As I mentioned at the start, the Commission has corruption prevention and education functions. In our first 18 months of operations, we've delivered about 125 prevention education sessions to parliamentarians and across many government departments and agencies. We use these sessions to provide those who might be exposed to potentially corrupting individuals and influencers, particularly ministers, their advisors, and senior public officials in the Commonwealth public sector, with the wherewithal to recognise and resist them. In line with what I said before about conflicts of interest being the root cause of most corrupt conduct, we particularly focus on uplifting people's understanding about how to recognise and manage conflicts of interest. Secondly, we actively encourage individuals who may become aware of corrupt conduct to report it to us so that it can be disrupted, exposed and deterred in future, and to ensure they know how to do so and of their rights and protections. Our website and social media postings are key ways we raise public awareness about how to report corrupt conduct. We also attend community events, speak at a range of conferences for those who report. These are also referred to as whistleblower protections, such as protection from reprisals or detrimental action and from criminal and civil liability. Such witnesses are very important to our investigative work in Australia. Thirdly, we participate in a range of cross-government efforts to uplift the integrity culture in the Commonwealth public sector. This includes working with the Australian Public Service Commission and the Attorney-General's Department on a number of integrity reform projects arising from the recommendations of the Robo-Debt Royal Commission, which you can find out more about in the Australian Public Service Integrity Taskforce report, Louder Than Words report, published in November 2023, which I'm also very happy to forward a copy of if you don't have access to that already. And finally, our legislation also allows us to conduct public inquiries into corruption risks and vulnerabilities and measures to prevent corruption in Commonwealth agencies. Public inquiries present a great opportunity to publicly expose corruption issues that might otherwise not be getting enough attention, and for a range of experts to assist bodies such as ours with advice on the preventative approaches most likely to be successful. I also note in a paper written by Transparency International back in 2017, other important anti-corruption tools relevant to climate finance they noted are identified as having strong governance arrangements, having legislative frameworks for the use of climate funds, making sure there is transparency in the finance arrangements, and ensuring there are plenty of external and internal accountability and controls over how climate finance is being managed. And the UNODC and the World Bank in their recent paper have gone further by specifically suggesting the following measures be considered: introducing or strengthening climate budget tagging and enhancing accountability of climate-related public financial management, adopting and implementing regulations to enhance and standardise climate-related disclosures by public companies, mainstreaming the adoption of ethics and integrity standards in the management of climate funds, specifying governance, accountability and transparency mechanisms in the framework legislation governing the structure and use of funds, supporting the involvement of civil society, including the protection of investigative journalists in the oversight of climate funds, and implementing mechanisms that allow for funds recovered from breaches of climate regulations or corrupt acts to be used to compensate the damage and benefit most affected communities. They also note that measures to classify environmental crimes as a predicate offence for money laundering could aid in these efforts. And in the area of carbon markets, they suggest the need to develop robust regulations for compliance and voluntary carbon markets grounded in scientific evidence and cooperative efforts with the private sector, ensuring that communities most vulnerable to the consequences of climate change reap tangible benefits. Cross-border cooperation in standard setting for the voluntary carbon market, encouraging collaboration across sectors to prevent the creation of isolated operational frameworks and to guarantee effective carbon offsets, introducing oversight regulations or guidelines to enhance carbon market integrity and effectiveness, strengthening corruption reporting mechanisms in this area and whistleblower protections, and regulating and enforcing greenwashing standards and associated fraud offences and embedding these in private sector compliance programs. So I highly recommend that paper for those of you who are interested in it. And on a final note, the need for international cooperation to tackle the corruption risks in climate finance is very important to us. This could be through the sharing of intelligence, in accessing evidentiary material, in bringing perpetrators to justice, and in recouping assets. That, we know, is easier said than done, because concurrently we must recognise that we have diverse political and legal systems which we must respect. The extradition of offenders and the recoupment of assets will always require formal procedures, but there are preliminary steps that do not. Where appropriate, and to the extent that domestic legislation and operational imperatives permit, anti-corruption commissions, for example, can proactively refer information to each other. We can share relevant information and intelligence, and we can cooperate in the investigation of cross-border corruption. So once again, thank you so much for asking us to participate in your conference. That's the end of my formal remarks. I understand we've got some time for questions and discussions before my session ends with you today. Thank you.
Very much. Very interesting. I just have a question on about greenwashing. I'd like to know whether you have greenwashing.
So I'm really sorry, but you're breaking up. Was the question about greenwashing?
Correct. And whether you have any examples you could share with us?
I'm sorry, I don't at the moment. It's not something that like I said, the Commission's only been going since July 2023, and we haven't had any referrals of such matters to us yet.
We actually have 2 more questions, and we'll be posting them in the chat for you.
Or funds, what specific powers does it have to freeze assets or suspend programs, make binding recommendations to government departments, or refer matters for prosecution? So thank you for that question. That's a great question. So we don't do the freezing of assets. That is something that we rely on other bodies to do. I know your Anti-Corruption Commission does have those powers, but we do work in a joint way with the agencies that are able to freeze assets at the Commonwealth level. In terms of suspending programs, it would be more likely that we may make a recommendation to government that a program should be suspended. It may be that, or even terminated. It may be that at the point when we start investigating a matter, if we get to the stage where we think we need to share information with, say, a head of a government department that was responsible for funding a particular agency where we hadn't completed the investigation, but we had enough information to suggest that there was corruption at play and that head of agency needed to know about it. We do have those powers to share that information so that we could suggest to the agency head that they might want to consider exercising their powers to suspend programs. We are able to make binding recommendations on government departments. We are also able to make recommendations to the head of the Australian Public Service Commission about termination of particular public officials. So, for example, if a senior public official was found responsible for the corrupt conduct that was occurring, we may make a recommendation that that person is terminated from their employment. And then in terms of referring matters for prosecution, yes, we refer, so we don't bring the prosecutions ourselves. The Commonwealth Department of Public Prosecutions takes those matters off our hand. DPP are running those prosecutions for us. So then question 2, in terms of appointment processes, could you explain how commissioners are selected and what safeguards exist to ensure the independence of these appointments from political influence? Again, another really great question. So I'll go back to the start. So under our Act, we have a commissioner. Commissioner Paul Brereton is the current commissioner, and he is assisted by 3 deputy commissioners. So I'm one of the 3, and there's also Dr. Ben Gauntlet and Ms. Nicole Rose. We are all appointed under the legislation. We have to go through a process. So particularly for the commissioner and Dr. Gauntlet and I, we are legally qualified commissioners. So there are requirements under the legislation that at least some of us need to be equivalent to a High Court or Superior Court judge. Our appointments are for fixed terms. In the case of the NAC commissioner, he's not eligible for reappointment. So he gets appointed for 5 years and he can't be reappointed. The deputy commissioners, we are also appointed for 5 years. We are, however, eligible for reappointment. And in terms of other safeguards around ensuring our independence, so although we are appointed by the Attorney General, the appointment instrument comes from him, we go through a vetting process. So we have a few things happen. So there's an independent selection panel that is used to, every Commonwealth agency has to now have a public interest disclosure coordinator, and people make disclosures to that coordinator. Now, when that coordinator receives that information, if it hits the thresholds for us of it being serious or systemic corrupt conduct, they have to report that to us. So sometimes we will find out about it through the PID coordinator, and at the agency level, that PID coordinator remains responsible for protecting the identity and the safety of the employee while they're still in the agency. So there's a range of things that go on in terms of protecting whistleblowers. So that kind of leads to the next question. Oh no, it doesn't. Sorry. So question 4: what challenges do Australian agencies face in detecting and investigating corruption related to climate governance and breaches of regulations? Well, I think they're the same challenges probably as are related to all of our corruption investigations. People can be reluctant to come forward. People are very good at covering their tracks. The amount of electronic communications these days in all of our corruption investigations, so like the digital forensic side to working out what people have gotten up to is massive. So the data that we have to first of all ingest and have the systems for sort of taking into account in our investigations, as well as the work that is involved in getting through that sort of volume of material, is enormous. And so it means that our investigations are often very lengthy. And the other thing I was going to say is we do also have, people use encrypted applications. The cleverest people definitely use encrypted applications. And while there is technology developing that will allow us to break some of that encrypted stuff, we're kind of always a little bit behind every time we work out how to get into a system, people invent new systems that are even more encrypted. So the technological challenge, I guess, for keeping up with how people go about doing their corrupt conduct these days are very alive for us. So question 5 is, what's the average duration for a case to be processed, and how does the prosecution occur, and the duration for investigation? Look, it's variable. I worked in the Victorian Independent Corruption Commission before I came to the National Corruption Commission. So I've got sort of 3 years experience at IBAC, as well as my, coming up to a year's experience here. What I would say is, in terms of the duration of investigations, some can be very short, but that is unusual. It's more likely that our investigations are going for 2 years or more. In terms of the time it's taking to prosecute matters, one of the issues that we've had in Australia is that during COVID-19, a lot of our courts stopped sitting for at least 12 months. In the case of Victoria, it was nearly 2 years where we had no capacity to get matters into court. We are still dealing with those backlogs. So some of our matters have taken more than 3 years to get before the courts. Things are rectifying more now, and things are getting a bit speedier, but we are finding that from commencement of investigation to successful prosecution, it can be 6 years. I remember there was a case that I was working on before I left IBAC, where I think we were up to the 10th year of still being before the courts, because the particular people in that matter that we were prosecuting were using every avenue they could to appeal and take every procedural point that they could. So that was that was a very, very long proceeding. So I think that answers question 5. And then question 6 from the Association of Persons with Disabilities: based on my legal aid background, how do you ensure that investigations maintain procedural fairness while still being effective, especially in complex cases involving multiple government agencies? That's a great question as well. Thank you very much. So yes, I do have a background as a legal aid lawyer back when I was a much younger person. Look, in terms of how we ensure our investigations maintain procedural fairness, some of that is in our legislation. So our legislation is quite prescriptive about how we go about ensuring procedural fairness. Some of it is just application of the common law around natural justice. So if we are investigating a matter and you are a person of interest, it is more likely than not that at some point we will bring you in for a hearing where we will put to you all of the allegations and all of the evidence that we have, so that you are given a proper opportunity to address the claims against you. Then again, when we are at the stage of, if we're going to write any sort of public report about your conduct, we have obligations to give you a copy of anything that we're going to say that might be sort of adverse or critical comment about you, so that again you have an opportunity to make submissions to us. In terms of also protecting the welfare and well-being of anybody that is involved in our investigations, we now also have witness liaison officers who work with us on ensuring that everybody who is involved in being a witness before us, so that can be the person who the allegations are against, but it can also be the people who are assisting the allegation by bringing evidence before us of the corrupt conduct. We make sure that they are looking after those people's psychological well-being as well as their safety, So I particularly consider that, an aspect of procedural fairness, as well as about keeping everybody safe, and as well as we can, knowing that corruption investigations, whether you're involved in them as a person who's giving information or a person who is subject to allegations, can be very stressful for everybody involved. And then the other thing I'd say about, yes, the point about complex cases involving multiple government agencies. So there's the procedural fairness that we have to apply to the particular people, but equally, if we are making commentary that is critical of the agency itself, so often what we'll see in our corruption investigations is, there'll be the bad person who's done the wrong thing, but there may also be things at the agency level where people knew about the conduct and didn't report it, or people knew about the conduct, turned a blind eye to it, or there are system vulnerabilities in the way that something about the government agency is operating that we need to call out and be critical about. Now, if we're going to make any of those criticisms about how the agency either managed that person or how its agency or how it runs its programs or procedures, the agency head also has to be consulted about those. So we also have to give procedural fairness to those government agencies who we might be being critical of. And then question 7, I mentioned carbon markets and the potential for it to be fertile ground for corruption and the potential for embezzlement. Could I explain this a bit further, and what are some of the ways for prevention? Well, carbon markets, I think the thing about carbon markets is it's just such a new and emerging area, and it's all a bit unclear at the moment, I think, how some of the checks and balances are meant to work in terms of how we're verifying that, for example, if we are funding someone to reforest a section of Tasmania, how do we go about guaranteeing that the money that we've given for that process has only been used for that reforestation project in Tasmania? And we know, for example, in the Australian context, we do know that the forestry sector in the past has been known for not necessarily using public funds in the way that they have been granted to them. So that is something that troubles us, is how do we follow the money and make sure that we're guaranteed that we are getting the carbon offsets that we're promised by the various proposals that come forward. And in terms of ways for prevention, I profess I am not an expert on carbon markets, and what I'd really recommend is that paper that I mentioned in my speech, which I'll just see if I can find it. So I think I mentioned in the speech a piece of work that was done, the independent review of the Australian carbon credits unit scheme, I think it's called. The report's available on the Department of Climate Change, Energy and Environment and Water's website, and I'm happy to get that for you and send that through to the conference organisers, because I think that's probably the most comprehensive report that's available in Australia at the moment about what they're saying about how do we shore up the integrity of the Australian carbon market. Also, the UN ODC World Bank paper that I mentioned as well has a really great section in it just specifically about carbon markets and what they think could be done to prevent some of the corruption risks that they're calling out. They do also note that, a lot of this stuff, it's new and emerging, and we need to all keep working together, I guess, on kind of scoping out the corruption risks, understanding them, and designing approaches to how to prevent it from happening in the future. So I'm sorry it's not the best answer, but definitely some resources that you can dig into from Australia and the UN if you want to know more about that. And then the final question, so how is the cost or loss measured from cases investigated? Well, look, again, so for the National Anti-Corruption Commission, we are at we are at the beginning of our journey in terms of measuring costs of corruption in Australia. In the IBAC context, I'm just trying to think, we often the losses were measured in terms of how much money, like how much public money got diverted by particular individuals. And cases varied from, it could be, in the hundreds of thousands of dollars to the many millions of dollars. There was a case back in 2015 that IBAC investigated in our Department of Education where the chief finance officer had effectively defrauded the Victorian people of tens of millions of dollars that he had diverted to his own friends and family. More recent cases that I worked on at IBAC, we were dealing with, a chief executive officer of a train network who had taken a $300,000 bribe to gift a contract to a cleaning company that he had unfortunate personal associations with. So it's often measured in the monetary sense. I think what's really interesting to think about is like, how do you measure the non-economic impacts? And particularly when we think about the climate, how are we going to go about measuring, if our temperatures are getting warmer, our seas are getting warmer, the droughts and other, catastrophic fires that we have here in Australia, all of those costs are almost immeasurable, but absolutely consequences of corruption in climate finance. So I'm very conscious my time is nearly up. Thank you so much for all your questions and your interest in the National Anti-Corruption Commission. If you ever get the chance to come and visit us, we're very happy to host any visitors who would like to come and find out more about us. And if anyone's got any corrupt conduct involving Commonwealth public officials that they need to refer to us, we'd be very, very interested in hearing about that from you as well. So thank you again, and I really hope your second day of your conference is a great success.
Thank you, Deputy Commissioner Kilgour. The session was quite fruitful, and I noticed our participants were enthusiastically taking notes from your session. I would like to thank the Australian High Commission and for the Anti-Corruption Commission of Australia for facilitating this keynote despite the short notice. I hope we meet in another occasion, and I hope you get to visit to Maldives as well. Thank you.
Well, that would be lovely. Thank you so much. Thanks again, everyone, and goodbye.